today, and we warmly welcome all of our physicians and healthcare workers. Thank you all for your selfless service in the war against COVID-19. We'd like to give you a round of applause for your courage and valor as we honor you. Thank you. So the topic for today's session is strategies for J-1 physicians to survive and prosper in the time of COVID. My name is Benjamin Hu. I'm an associate attorney with Maggio, Kattar, and it is my pleasure and honor to introduce our seminar leader, Jan Pederson, who is senior attorney and shareholder at Maggio Kattar here in Washington, D.C. As many of you know, she's a household name in physician immigration, having devoted over 30 years to advocating for J-1 physicians on Capitol Hill, in the White House, and with numerous government agencies. She was a co-founder of the International Medical Graduates Task Force in 1990, and she was awarded the Lifetime Achievement Award by the task force for her extraordinary service to the physician immigrant community and their employers. She successfully represents thousands of J-1 physicians and their employers. We have a very special guest speaker with us today, Mr. Greg Siskind, who is a veteran advocate for J-1 physicians and a friend and colleague. He has worked tirelessly behind the scenes on the legislation to benefit you. We are proud to announce that the HEROES Act passed last night in the US House of Representatives. Thank you to Jan and Greg, and also a shout out to PAHA for their tireless work in this legislative field. So the format of today's meeting, we will take verbal questions and also written questions via the chat, which we'll delve into in the final 15 minutes. Please feel free to type in chats generally or use the raise your hand function. And any questions that we do not get to today in our speech Q&A session, we will get around to by email very soon. You will all be muted until we call upon you to ask a question, and we will unmute each user as we call on them. As you can see behind me, I have the Maggio Kattar contact information for Jan Pederson on the screen. Feel free to note that down, and if you have any questions you wish to ask privately or directly to our attorneys, please feel free to do so. As for the content of today's meeting, we will first get to the true facts of the 3 bills pending in Congress, and then we will go to the bread and butter of your personal solutions with and without legislations coming up. So thank you very much for your time, and without further ado, I would like to present our speakers to you, Jan Pederson and Greg Siskind.
Thank you very much, Benjamin, and thank you all for attending. It's just absolutely wonderful to be able to share what we know with you. None of us think we know enough. And first, I would like to honor and shout out the wonderful doctors of PAHA who have made the HEROES Act and aim to make the other legislation a reality. They have worked tirelessly, knocked on every door that they could, and got strong support for our HEROES legislation. I would invite all of you to join with PAHA. Just go to paha.us. Now, the great news, you all have already heard misinformation about us in the HEROES Act. My good friend and colleague for many years, Greg, is going to talk with us about what is in that bill and what is not, and he's going to share with us what it looks like for passing the HEROES Act in the Senate, which passed late last night in the House, and the 2 other pieces of legislation. Then I'm going to ask Greg a bunch of questions. And I love it that some of our doctors are so tired that they're listening to this webcast from their beds. That's wonderful. Feel free. So Greg, the HEROES bill passed last night, and please give us a summary of that bill, as well as the Purdue bill and the Healthcare Relief Workers Act. We're all trying to know, and the doctors all want to know what's in it for them as a reward for their wonderful service to America.
Yeah, so this is a tale of 3 different bills, and we are not, it's not really clear yet which of them is in the lead as far as a race. And there may be at the end some kind of combination of these bills. But last night, the HEROES Act passed 208 to 198, I believe. And it was part of the $3 trillion COVID relief package that is where the immigration may be important to you guys, but largely in the grand scheme of things, the media paid almost no attention to it because it occupies just a couple of dozen pages out of a 2,000-page bill. So it passed. That bill itself is when it gets over, it's not going. Mitch McConnell in the Senate is not going to take up that bill, and so it's not. In a better world, it would be, the bill would go over there and they would just vote on it up or down. But what's going to probably happen is the Senate, first of all, it's not clear they're going to do any bill on COVID, another COVID relief bill. But this week, the chairman of the Federal Reserve, Powell, suggested that Congress really needs to do another bill on this. And also the unemployment rate came out and another 3 million people applied for unemployment in just the last week. So there's a lot of pressure on the Republicans on this, who control the Senate, to do a COVID bill. So they're going to go on vacation in a couple of days. They're in session until for like 4 or 5 more days. Then they're going to have a Memorial Day recess, and then they'll be back about a week later. So when they come back, that's the question, is whether they're going to take up their own bill. And if they do, there are 2 bills in the Senate that are gaining some traction. One is Senate Bill 3599, the Purdue bill. And I'm going to talk about what the differences are between these. That's one that just was introduced a couple weeks ago. And then there's a bill that Jan and I have been working on with PAHA. Jan and I know have been working on this bill for at least 15 years. The last physician immigration bill that passed in this country was in 2004. And we've been working on this bill ever since. And that bill is Senator Klobuchar's. She's the lead co-sponsor, and the bills in the Senate are very bipartisan. So there is hope that if the Senate produces a COVID bill, that it will have physician and healthcare worker provisions in it for immigration. And then what would happen is they still have to work out some kind of deal with the House. They really want this to become law, and they're going to have to compromise on all the controversial stuff with the money, but also on the immigration provisions. So what would likely happen is that the House Immigration Subcommittee staff and the Senate Immigration Subcommittee staff would basically sit around a virtual roundtable and start hammering out a deal of what they would want to see on that language. By the way, there's a bunch of other immigration provisions on the HEROES Act that passed last night. Some of those are much more controversial than the doctors. So you may hear about other provisions that are that people are talking about immigration-wise with the HEROES Act, but I'm only going to be talking about the doctor stuff today. There is something that tangentially affects backlogs. Well, it's not tangential, but it involves role. You may be seeing it on Twitter and other places where a part that talks about family immigration numbers not rolling over to the employment side. And if we have time, I'll talk about that. But Jan, you asked me about what happened in this bill last night. I can tell you that the approach that the House is taking is more in lines with immediate issues that are related to the pandemic. There are some green card provisions in there, one of which is not really an immediate issue, but you'll start to pick up on the theme when I describe what's in there. But the first section in this bill is for physician national interest waivers, but it's a very narrow bill, a narrow provision. And basically, if you have a physician national interest waiver that's already been approved and you have finished your 5 years of service already, those are 2 pretty important conditions, and you've done some work that is COVID related, which means doing something in the treatment, diagnosis, or prevention of COVID, then you are put into a category that doesn't have any green card caps. So you would be, that group of doctors will go automatically to being able to get a green card. Their numbers don't draw from the employment-based preferences. So every doctor that gets into that category, in theory, speeds up the line for everybody else. So that's how that provision works. There's also some language on, many of you may know that premium processing is gone by the wayside since the pandemic began, and that's caused all kinds of problems for people that are trying to change jobs or make amendments. And the only thing you can do right now is file for an expedite request, and expedite requests are oftentimes much harder than they need to be, and they're not always granted, even though people are deserving of it. But the House provision basically says that anybody that's any healthcare worker, not just doctors, who are engaged in who are dealing with COVID, when they file for any kind of non-immigrant petition or an application, there's a 30-day time limit for adjudicating those cases. Basically, the Immigration Service has 15 days after they get the application to review it, and they have to issue a decision. At that point, they have to issue a request for evidence, or within 30 days, issue a decision. And if they give you a request for evidence and you respond to it, they have 15 days to reply from that point on. And that's only during this is not a permanent change. It's only during the period of the emergency, and it ends 180 days after the emergency declaration is declared over by HHS. There is provisions for the Department of State on emergency visa processing. So basically for healthcare workers and medical researchers who are doing anything that's COVID related, the Department of State is directed to schedule appointments within 7 days after a request is made. And they also are directed to waive interviews if it's a renewal of a visa in the same category and at the same consular post, and the person doesn't have any apparent violations of immigration law in the past. There are provisions that are designed to make it easier for doctors to be able to more easily change locations without having to file new or amended H-1B petitions when they are going to new areas of employment if their work again is COVID related. There are provisions for J-1 doctors that are that give more authority for doctors to do work outside the scope of an approved program if the work is COVID related, you're maintaining your non-immigrant status and complying with the terms of the program, and your responsible officer okays the additional work. There's also a provision in that section that J-1 waiver work can now include telemedicine. I should say that it would include it, because people just need to make sure they understand that this is not the law yet. This is just what one House of Congress has approved. There is a provision that for O1 visa holders that portability would be available to them like they are for H-1B doctors, which means that you would be able to start work upon filing a change of O1 employers without having to wait on the approval. And one that's that sounds pretty technical, but it's going to make life a lot easier for J-1 doctors, is the elimination of the bar on changing status in the United States for J-1 visa holders. That's a very, very significant change. It would allow people, for example, to change to H-1B status in the United States, even though they're subject to 212E. It would make it easier for, in a lot of instances, for people to be able to work. The good news is that while a lot of those provisions are limited to only the COVID period, the telemedicine, the O1 portability, and the end of the change of status provisions, those will be made permanent. There is a very nice change for the Conrad 30 program for J-1 waivers. There's a permanent hike of the numbers to 35 per state from 30. So that's going to, that should make it a lot easier to get in certain states to be able to get a waiver. There's also a provision that allows that program to grow by 5 per year if there's a lot of, if it's a very busy demand nationally. There's a section that provides employment authorization documents to doctors and other healthcare workers who are going to work in COVID hotspots independent of your visa status. And then finally, there's a provision that a lot of people are chatting about called special immigrant green card status for certain doctors and healthcare workers and medical researchers. And this provision would provide for 12,000 green cards for physicians, for healthcare workers, for medical researchers who are doing COVID-related work. And the way that program would work, it would be a self-petitioning process for it, so it's not employer-driven. You can file for yourself if you meet the category. Up to 4,000 would be available per year for the first 3 years, and then anything that's not used in that number would roll forward to future years. Family members are not counted against the 12,000, which really means that it's probably more like 20,000 green cards that are going to be granted in that category. And there's also a widows and widowers and orphans provision, which basically says if you are in the process of getting a green card and you pass away, that your family members can still continue on to getting the green card, even with the principal applicant no longer being alive. So that is, Jan, the nutshell version of what just happened last night.
Okay, Greg, thank you. Now I'm going to be a CNN reporter and ask you a ton of questions here, and you all feel free to chime in. So everything, be clear, everything you just talked about is in the HEROES Act, correct?
That's what the House just did. That's not what when we were talking about the Senate. They're taking a very different approach.
Right. So, question. So everybody's really excited that somebody finally recognized and paid attention to the enormous contribution of foreign medical graduates and other healthcare workers. So question number one, looking in your crystal ball, what is the likelihood that the HEROES Act will become law?
I think that the HEROES Act itself, I think there will be a COVID relief bill coming. I just think that it's too politically dangerous for Congress to not do something at this point when you have just, really conditions that are fairly similar to a depression going on in this country right now. So there will be a bill, and if there is, there has to be some discussion on, they're going to have some kind of discussion with the House about the immigration provisions. And there are some pretty attractive bills in the Senate. So I am optimistic that if the Senate does a bill, they're going to put the Purdue bill in, and we're working hard to try and get the Klobuchar bill in as well on there. And we'll be having a lot of meetings over there. And it's kind of good that the Senate is not about to introduce their own bill, because we probably need about 2 weeks to work on trying to get them to include it. But I think that if those provisions end up in there and there's a negotiation with the House over it, I think some of those provisions that I was just talking about, and maybe all of them, will end up in a compromise bill, along with hopefully some of the best stuff from the Senate side, which really kind of takes a very different approach. When we've been talking with Senate offices, we've been saying each one of these bills essentially solves a different problem. And there's no reason you couldn't combine all three of them into I could, by the end of this afternoon, I could have a bill drawn up that would be comprise the best of all three of those provisions, and they don't contradict each other at all. So I'm an optimistic person by nature, but I've been at this for 15 years of basically not getting anywhere, but I feel like we're pretty close.
Thanks. I'm going to race through the rest of the questions, and we have some from the audience. So the Durbin bill, the Purdue bill, will give 15,000 green cards to physicians. There's a lot of confusion about that is also just a bill, not legislation, and not the HEROES Act.
Right.
Now, the great thing about the 15,000 green cards in the Purdue Act, just think chicken Purdue, 15,000 green cards. Do we have an idea of how many all those 15,000s go to EB2 positions, and their dependents are not counted against 15,000? So the very common question is, how many EB2 principal physicians are in the waiting line, and how will that be chopped down, and when do you have to have a petition filed or approved, or in other words, have this priority date secured?
So, good question. The answer is we're not sure. The Immigration Service doesn't provide occupation-specific information on people that are in the backlogs. So we don't know for sure. What we have done, the PAHA folks and I have kind of done some back of the envelope math, looking at the number of J1s that have come into the country, looking at the percentage that are from India and China, looking at the number that got waivers. We don't know, we don't know the percent by nationality of who got the waivers, but we believe it's somewhat higher, a higher percent are Indian than in the general J1 population. And with all that said, our guesstimate was somewhere between probably 13,000 and 20,000 are in the backlog, but we don't know for sure. That being the case, the 15,000, I would be surprised if there are any leftovers from the people currently in the backlog, and I'm not optimistic that it's going to really help people that are that are still in J1 training or haven't started the green card application process yet if they're done with that. So probably the HEROES Act can help people that are currently in J1s right now, and the Klobuchar's Conrad bill could potentially do that, but it's not going to happen with Purdue bill. One other thing I would want to mention is that physicians is not actually defined in the Purdue bill, and there's been some question about how broad physicians actually is. There are federal definitions for Medicare purposes and other places where physician is defined to be more broad than just MDs and DOs. For example, the Medicare definition of physician includes dentists, and it includes chiropractors, and it includes podiatrists. And some of them who have, there are much smaller numbers of them in the backlogs than physicians, but that might also potentially affect, how quickly those numbers go.
Right. And two other points there that in the definition, in other words, are medical doctors not the only ones that would get in on the 12,000? For example, physical therapists and pharmacists. Today,
in the HEROES Act, it's healthcare workers, also not defined. So I think physical therapists can make a very strong case that they are intended to be included in that. Medical researchers, I've had a lot of questions from people saying, it's like, I'm working as an engineer designing something that's related to ventilators. Does that count? Or I'm, things that you're starting to get, it's starting to become clear that how unclear when you don't have definitions, who's actually included. So it will be interesting to see, whether it's left that way and we just have to make our case to the Immigration Service, or the Immigration Service steps in and puts definitions in that makes it clearer about who it applies to.
All right, so that's another signal for everyone to contact their senators and congressmen. And you don't have to have a green card or citizenship to be listened to, as PAHA demonstrates. PAHA generally is people that are on the forever H-1Bs. Don't be shy. You find out who your congressman is, Google who is my representative, put in your address, and don't be shy. It doesn't have to be a PhD dissertation or your superior is rounding with you, criticizing your work. A letter from the heart. I have done this, and that will work. So the answer is we've got great things in the works that all need a push. Benjamin, do we have any questions for Greg on the legislation? If not, I will go to what else can I do and what's going on now administratively? How can I get to work on time and stuff like that?
Yes, indeed. We do have a few questions. Regarding the proposed legislation, we have one question from Kalpesh saying, will these provisions apply to only current H-1B physicians who have worked with COVID-19 patients, or could they also apply to current J-1 residents in the future as well who work with COVID-19 patients?
For the HEROES Act, it could apply to J1s, but, and I should have mentioned this, it doesn't get you around the J1 home residency requirement. So you still are going to have to do a waiver. However, you can potentially file for a special immigrant number, and it will be, and those numbers are going to be only 4,000 per year. You can potentially claim they're going to be adjudicating in the order of petitions. So if you qualify at the beginning, but you have a 3-year home residence requirement, I would still probably recommend filing for a special immigrant under the provision and get a place in line, and then hopefully there still will be numbers available. And if there are numbers available when you are eligible, then it's going to be, they're doled out in the order of the date that you filed. So if you filed early and then you're stuck waiting for a while and there happen to be numbers left at the end, you'll be at an advantage having filed early because your priority date will be earlier for that program.
So if the HEROES Act passes, then we're all going to be sleeping at the USCIS office a couple days before it opens for new filings, like we did in 2007.
Yes, good times.
So much, Greg. So now you're all saying, what do I do? What is, the government isn't saying anything clearly. The House passes something, other things in the Senate. What is actually real on my plate today that I can use in making plans? We hear from many of you, and you're all worried and scared. Know that you are really supported by a broad base of people, including the ones who makes the laws in Congress. So we're going to look at some solutions and look at some different situations of 3 groups of physicians who are really anxious about their futures right now. Greg and I and other organizations have worked together and made 51 requests of, is 51, Greg? 51 requests of USCIS for administrative fixes. These are fixes that don't require a change in the law, a change in the regulations. Basically, with a flick of a pen, it's done. These are changes that they can do easily and morally should do. So these are on the administrative side. USCIS, you need to hurry up and approve this, that, and the other. And there is a lot of support. And in this, the provisions in the legislation that Greg was just talking about gives them 30 days to adjudicate your benefit. While that is not the law, we can argue that it's the sense of Congress. So they're very slow to act, as you all know, which is generally the way of all governments when making a request. So our first group that we hear from are J-1 physicians who are supposed to start residency on July 1st and need an fairly instant change of status to J-1. We think that immigration is aware of this, but as Greg mentioned, you have to make a special request. So there never has been premium processing for a change of status to J-1 to start your program, but they've generally been receptive to the need of your program and you to start work on time and the needs of the American citizens who you will care for in your training. So as we all know, you generally all have your DS 2019s by now. What should you do? Well, first I would go to the people in your program and ask for a support for your expedite request, explaining the need for you to be to work on time. For example, if there are 4 fellows in your program and you and your friend are both trying to change status to J-1, that's pretty compelling. It's a 50% loss of the workforce. We always write a cover letter for ours, and we have a big red stamp that says, "Physician waging war on COVID-19, please expedite processing." And we write it all over in red so they can't possibly miss it. So while we can't guarantee that they will do it, I think they seem to be receptive to it. We're now, 6 weeks away from your program start. It's not time to panic. June 15, yes. Another avenue you should pursue is contacting your congressman. Again, they do listen. You will deal with the caseworker. You go to their website, and they have a form, a Privacy Release Act form, which you should complete and just write on the top in red, "Physician working on COVID. If that's the case, I've not come up with any position yet who has nothing to do with COVID or COVID patients or the impact of it.
Or prevention.
Prevention, treatment, diagnosis, and treatment. For example, we have a couple of pathologists, and the one was, how are we fighting COVID? Well, obviously they're on the front lines of COVID, and we just have to put it in the terms that USCIS can understand and relate to. So after you file for your change of status with a hopefully strong letter from your program director and a strong letter from the attorney, you get a receipt. Once you get the receipt, you want to go to your congressional office for help. And a lot of questions come up, well, I'm in the process of moving, which address do I use, which congressman? I would contact the congressman in the place where your residency is. And you will be surprised that they are helpful. These are solutions for people in the US. Actually, strangely enough, it's very clear if you're outside the US, but please do not leave the US for this reason. This is not the message. I know some program directors are urging people to leave. I think it's a really, really bad idea, even if you can leave and come back and you've got quarantines there, quarantines here. You know, the program directors have pressure to get you there, and sometimes it's suggested by the program people to leave and get a visa. Now, if you happen to be outside of the US, I do see we have some foreign participant people abroad listening in here. Thank you for coming. The one clear thing, probably the clearest thing we have, is a directive from the State Department to give emergency visa appointments to all healthcare workers. And the way that you do that is you go on and make your visa appointment and clearly state in your visa application, we complete the visa application, then you make the appointment that you are a physician and you are coming to a residency program and will be working in the war against COVID in America. So each consular post has a little bit different procedure, but they all have a procedure for requesting an emergency appointment. They're supposed to give them within 7 days. Let us know if they don't. So those people should be able to get here. Now, group number 2. About to finish your residency on June 30th. And all the parts aren't together yet. You've got a J-1 waiver employer who wants and needs you. You've got the waiver in process, H-1B in process, and you're very worried about when and where it's coming together. We're pretty confident that it will come together for you to get to work on time. The Department of State is cooperating with expediting the waivers. Some of the waiver agencies are expediting, particularly HHS. Shout out to HHS for their great work in getting the waivers out. And then it's time to file the H. Some of the issues we're seeing in the H's is, can I file my H-1B if I don't have my medical license yet? If the difference is between you being out of status and not, I would say file it. We've made a request that they accept H-1B petition, that USCIS accept them without the license if you show that you've applied for a license and you're waiting for it. A lot of people seem to be in that situation. Now remember, the last day you have to file without any of the ameliorative processes that we've suggested to the government is 30 days after your program end date listed on your DS 2019. So if your program ends on June 30th, you can file your H-1B petition up till July 29th. You want a little cushion there, but that's the situation. You do have a bit of a cushion there. Should you file without an H-1B petition? Without a medical license, if you're coming up to that 30-day period. What would you say about that, Greg?
Yeah, so the question is, should you file during the 30-day grace period for the H change?
You don't have your medical license yet.
Yeah, I would file it. Well, first of all, one thing to check is whether there have been any changes in the state where you're going to regarding licensure, because and there's a chart somewhere, but that I saw not too long ago about like almost every state has made some changes to their licensing rules to speed up and make it easier for people to get in. So it may be that you don't have to actually have that the rules have changed somewhat. But yeah, I would file, and there's a pretty decent chance you'll get a request for evidence as opposed to a denial. The other thing is, Jan, I'm curious about whether you're, how, I know USMLE 3 has been disrupted, but is now, I guess, apparently just started being offered again after the,
Yes.
that's a requirement for H-1Bs. And I'm curious as far as whether you've heard anything regarding people that are still waiting to get the USMLE 3 part done, whether that's affecting H processing or not. I haven't heard that yet, but I'm curious if you have.
Right, I believe most people have completed USMLE 3 before they finish their residency. Please, one of the audience, fill us in on that. And if please speak to your employers. Don't be shy about it, to expedite your license. Many employers can, and they all have relationships with the licensing people because they have to interact with them. They historically have a strong relationship, and if you're going to work, particularly for a community health center or a hotspot, I found the employers are very helpful in getting licenses expedited. Now, what we're concerned about on the cross-border honoring of medical license is that the temporary licenses that, for example, New Jersey will give to a doctor with a New York license, or New Jersey will give to a doctor with a Pennsylvania license, are temporary, and that could cause its own problems, but I would certainly take that over nothing, a temporary license. So if you have a license in one state and the state you're going to has enacted COVID waiver, licensure waiver provisions, that is will be acceptable too. We also have
but you should include documentation of that with the application from what the
oh, absolutely,
that the state is that's the state you're going to. There's probably an executive order or something where it specifically mentions it.
Every state generally will have an executive order, and there is a chart somewhere, but it changes daily. So it's best to just check on the website of the medical board of your state of intended employment. It's also could be on the governor's website. Now, if worse comes to worse, and you've got licensing delays, you've got waiver delays, or whatever you can, the USCIS has always had the authority to excuse a late filing as long as you don't engage in unauthorized employment. So that is an option. It's not what we love to do, but sometimes we're forced to do. So you need a good reason for late filing, and if you have no other choice, they seem to be fairly, we had two that we had to file late because the paperwork hadn't come through, and they were both excused. We made the argument, it's not your fault, it's not the doctor's fault, it's not the employer fault, there's some glitch in the 6 government agencies which J-1 physicians have to go through to get to work.
Jan, what about extensions of your J-1 for during the summer for purposes of taking the boards? And have you seen any changes as far as that goes, or any difficulties doctors are having when they're making those requests?
No, actually, everyone who is able to, please extend your J-1s. No matter if you think everything's going smoothly or if it's already done, extend your J-1s to take your board exams. So for some of you, that can mean an extension until November 30th. If your board exam is prior to December 31st, the ECFMG will give you an extension to take your boards. Now, we have been in discussions, and many people have been in discussions with ECFMG about extending your status until you can get your waiver and whatever else relief might come from Congress in place, just an extension. We've asked that it be with work permit. That's kind of a big ask, but we're hoping for it. ECFMG has been very slow to act in that regard, but do extend for the boards. Now, as far as your H-1 petitions, as Greg said, I don't know if Greg said, but there is no longer premium processing for H-1Bs. There are some unofficial rumors that it will start up again. The unofficial rumor from the government is that they will start on cap exempt case, which basically everybody with an interested government agency waiver is about June 15th.
There's some good news even without premium processing. The anecdotal reports from the IMG task force lawyers are a lot of people are seeing approvals coming in 3-4 weeks, sometimes even faster than that, without premium processing. So it's not all bad news.
No, actually, they're polite. We call it the silent benefit. They don't really want you all to know they're going to do it, or us either. But our task force attorneys all faithfully report in on what they're seeing, and we are seeing about three weeks on H-1B processing. So as long as it's timely filed, you can basically expect, without them USCIS specifically saying so, that you can have it in 3 weeks. So don't panic. Some of you might need expedites for EADs where you're doing your training or your work on an EAD. And they've been pretty generous with that as well. You might have to put in some extra information because they might not understand why a J-2 spouse needs a work permit. And you don't get an extension of your EAD while your request for an extension is pending. So like other applications, if you timely file an EAD extension, you can expect that your work permission will be extended. So Greg, did you have something to add there?
No.
Okay, I'm gonna do this quickly because I see we have a lot of questions coming in. We want to answer that. And I also see somebody disagreeing with us. So we want to hear from that person. Okay, so it's, I know, it's May 16th and you don't have a waiver yet and you need a waiver. What to do? Okay, so you all know about hardship and persecution waivers. If you haven't started one of those, it's a bit late, as they seem to take about 12 to 14 months. We have requested expedites, but the time, if you have to do it, that's what you have to do. But basically, you're going to be looking for a state or federal interested government agency waiver. Is the great news, that is new news for this call, is that HHS has broadened the types of waivers that will sponsor. We ask them to declare the entire United States a medically underserved area.
We got close.
We got close. They did something very good, and that is all work locations who have a federally designated shortage score, a HPSA score of 7 or greater, can now sponsor waivers. However, the other ask is they're still limited to primary care physicians. So if you had a hospital in a place that's out of a waiver, you want to quickly check to see if they have a HPSA score of 7 or greater. And the place you go to look for that is just Google HPSA, HPSA, find by address, plug in your location, and it will tell you the HPSA score. And you'll want to, they're broken down different ways. You'll want to look under the primary care HPSA score.
Yeah, and they're pretty fast at HHS about turning those applications around. So if you're late in the game, that's a good one to go for.
Yes, exactly. We're seeing approvals in a week to 2 weeks, and they're leaving there. We'll get to the backlog on the way from the interested government agency to the State Department in a second. So find those waiver jobs. Remember that all federal agencies can issue an unlimited number of waivers year-round. Totally no limit. Forget the word 30 that you know from the State 30 program, many states of which are out by now, a great deal of them. So think unlimited. I just have to be in the right place. So the first agency, just because we're going to talk about is Appalachian Regional Commission. It covers, and their website is arc.gov, and they will list the counties where they are operating. If you have a job offer there, and the other great news there is a year and a half ago, they expanded to include subspecialists. So it has to be a health professional shortage area, and they will accept any specialty. They're a little paperwork heavy and cumbersome, so you want to get all your allies, including your lawyer, your employer, your congressman, on those expedites. They're still accepting now. We are still filing now. So don't think it's too late. I'm finished. It's ruined. No, it's not late. If you're federal, you've got the Delta Regional Authority, which is super user-friendly, not paperwork heavy at all, and they do them very quickly. Should note that ARC and DRA charge $3,000. Is $3,000 DRA still, Greg? $3,000 filing fee?
Yeah, it's, I actually have over the years encouraged waiver programs to charge those kind of fees, because then they actually have the staff to be able to adjudicate them. They tend to be faster, and they survive those programs because there's it's a revenue generator.
It's financial incentive, yes, exactly.
So it's pay to play.
So, and DRA's website is dra.gov. They love their program. And just geographically backing up, ARC extends to counties from the bottom of the state of New York down to Georgia. Places in between. All of West Virginia is included, a third of Western Pennsylvania, parts of Kentucky and Tennessee. So that's the geographic area roughly. The DRA starts at the bottom of Illinois, the southern counties of Illinois, and goes down through Mississippi.
Yeah, I would just say, just add, if your priority is to be in a city, then this new HHS change is for you, as well as the DRA, because the DRA has New Orleans and Memphis in their footprint, and New Orleans and Memphis had basically unlimited waivers, and they both have very high percentages of their metro areas are underserved. And then the HHS, for instance, Jan, we just got one in Brooklyn, which I didn't think there were any rich areas in Brooklyn, and now we're using that program there.
Washington DC hasn't used up its waiver yet. They never do. You're welcome here. New Jersey hasn't used theirs. So we like the HHS waivers. We would like to add that. Now, other individual waiver questions, the expedite issue, get the waiver, get the age. Okay, so there's been an unreasonable delay in getting your waiver from, let's say it's ARC or HHS, to the State Department logged in. You say, what happened? Did they really send it? What happens is it goes through all these checks and delays, and we have word out to them. They definitely need expedite requests on them. And then, of course, when you get the DOS approval letter, you do not have to wait for USCIS approval of your waiver. Once you get the DOS letter, you can file your H-1 petition. So those are some of our solutions. We have 10 minutes left. Can we take questions? Benjamin, can we have the first question, please?
Certainly. We've had a couple of participants raise variants on the question about public charge, especially including the $1,200 for the tax rebate that was recently issued. Can a J-1 or an H-1B physician or doctor accept that money, or do they have to return it?
Yeah, that's pretty clear at this point that that's basically considered a tax refund and is not considered a benefit. So we're pretty confident that that's not going to cause problems with public charge.
Absolutely agree. Next question, Ben.
What options are there either currently or under the proposed bills for changing of status from J-1s to H-1Bs and Js to Os and back and forth?
It will all be permitted. And we have also had that request in administratively. I think somebody else asked if you can change from J1 to O1 while not currently permitted under the regulations, given the inability to get a visa appointment abroad. We have heard of several that have been approved.
Yeah, I mean, that's in the HEROES Act, that provision that bars J to other category changes is eliminated. So at least in the legislation. From USCIS at this point, you still have a bar on filing a change of status application from J to O within the United States. Although, Jan, I think some people have also been trying this method of going and filing an I-193 at a port of entry and just turning around and coming back on there. But I know there's been a lot of discussion about that on the chat board for the immigration bar.
Yeah, that is possible that you could go to a CBP station. I would not suggest you do it without representation and it being discussed with the border in advance. So people are getting changes from J-1 to O-1 in the United States. It's not the law, but I think that a strong argument can be made, can absolutely be made that you can't go abroad to get it, you're needed. And the United States Congress just passed a legislation that would make it a law. So it is basically the sense of the United States Congress says do it. Can we guarantee it? No, you have to be prepared for denial, but certainly this is the time, if any, to try. And again, always put in your how you are helping the war on COVID. Next question.
There's a more general question from one user asking, what are the steps and who are the people that they can contact to expedite the waiver? We've spoken about contacting the congressman. Who else should they have in their toolkit of contacts?
It depends on the waiver agency. Certainly the waiver agency, I assume most people have attorneys, so your attorney should be making those contacts with the agencies themselves.
You might also, like, for example, get a letter from like the chief medical officer of the hospital where you're going to, or maybe a county health official from the location where you're going to be going to. It's just some backup documentation that your work is pretty critical for a community.
Great. Next question, Ben.
Who can a physician or doctor contact at their institution or their hospital to see if it qualifies for FQHC or HPSA?
You can tell that by going to the website. HPSA, just Google the words HPSA, HPSA find, type in the address of your your proposed work location, and it will tell you right there what the HPSA score and whether it's a HPSA. There are a lot
but they were asking about FQHC designation. The other thing you can do is look up in the county. You can go look up a HPSA, all the HPSAs in a county, and it will tell you the facility by facility designation, and all the FQHCs should be listed, Jan, by county, if you look at it that way.
Right, so to just emphasize that, there are two ways to look it up, one by the address, and if it's a FQHC, that's a federally qualified health center, also referred to as community health clinics, you then go back to the HRSA.gov and then you search by county. So you need to know the county where you're located in. And then it lists out separately the qualified health centers and their HPSA score. You would rarely ever find one less than 7. Less than 7. You also find mental health HPSAs. You'll also find prisons and fun places like that on that same lookup. Next question, Ben. We've got 5 minutes left.
Many are seeing DOS delays. They're saying 10 weeks or even higher, and that's even for the Department of Health letter uploads. What can physicians do and put their hands into the process to push that forwards?
Make a lot of noise.
Make a lot of, exactly. Contact your congressman, have your lawyer contact them. But just remember that if your start date is July 1st in government time, I know it's hard to sit still and wait and not be anxious, but in government time, this is May 16th, and if your start date is July 1st, to them, that's not a government crisis. The government crisis is if something's going to go south really badly, and they're going to look really bad in 10 days. So while your expedite request can be made, be judicious about them. They'll look and they say, wait, it says they're going to start work July 30th here, July 29th, and, put that aside. So you don't want to request it too early or too late. The timing is essential. You want to be diplomatic.
When would you say is the right time? How many weeks out?
July 1st, I would say the second week in June.
Okay.
Yeah, and they will get on it. The other thing, maybe even the first week in June, because there are only a few people at the Department of State Waiver Review Division who work on these, and they're working from home, and we all have experienced the delay in results when the government is working from home.
Jan,
However,
I mean, in past years, it's been fairly loose about being able to file for that change of status to the H-1B upon the Department of State recommendation, versus waiting on the approval notice from USCIS. That's still our advice, is to file at that point, particularly when you're in a hurry.
Yes.
Any changes there?
No changes there, except hopefully they'll be more cooperative. So just to elucidate quickly, you can file for your change of status to H-1B as soon as you get the Department of State recommendation to USCIS. And you would think that the USCIS could talk to each one section to the other. One petition goes to the California Service Center, the waiver is scanned to the Vermont Service Center, and you have to urge them to contact each other. We write on it, please contact us, please contact your colleague at the Vermont Service Center, and they will approve or verify that they have approved it. And occasionally in the past, pre-COVID, there have been RFEs, but they've been handled. The small disadvantage, if they act like that this year, is that we don't have premium processing, and the advantage for your extra $1,440 that you pay for premium processing is we call somebody on the phone. And in the past, when that's been an issue, we could call premium processing and ask them to talk to their colleagues in Vermont and ping them and coordinate the approvals. Not really a problem. Next question, Ben. We only have one more minute. I guess we can go a couple over.
So here's one that plenty of physicians have been wondering about. Would it make sense to apply both for the physician's national interest waiver and the EB2?
That's like the most common question I'm getting right now.
Yes, I say yes. Greg, I say yes. And if your employer balks at paying for PNIW and PERM, they're legally obliged to pay for PERM. Not for the PNIW. I would say the physician should go ahead and pay and double their chances. There are too many variables. Greg may have a different idea.
No, I mean, it's essentially the same. I mean, the programs operate a little bit differently, so whether you get that same advantage, but what you want, and some of the, when there's a defined number of green cards that are going to be out there that might run out, first priority number one is to be able to get an adjustment of status application filed. Because once you have an adjustment application filed, if you ever, have H-1B problems, you have that backup, you have an employment authorization card, you have a travel document, you have the ability to move quickly from employer to employer. But that only happens when you get the adjustment application filed. With the PNIW, if, let's say, the Purdue Act passes and all of a sudden these numbers are available, what's going to happen in the visa bulletin is there's going to be a line that says physicians. And that will probably be current or from the very beginning of that program, which would mean if with the PNIW, you can file an adjustment application under the PNIW rules. You can file an adjustment application at the very front of at the very beginning of the process. So if they run out of numbers, you at least have that adjustment application as a permanent benefit that you would have if the numbers run out. But because the numbers are running out, the goal is to get to the point where you're qualified for a green card as quickly as possible. And a PERM is going to be faster than a PNIW as far as getting you to that point. So that's, in a lot of cases, I would say that Janice is correct. You should file both, not just because it improves your overall chances of qualifying under one of the two programs, but because your chances of getting one of those finite number of green cards is better with PERM at the end. But PERM, you can't file the adjustment application until you're finished with your J-1 service time. So that's why the adjustment application that you get with the PNIW is such a valuable benefit. It's a question. It's certainly something worth talking to your lawyer about, because
Ben, we have time for 2 more questions. And if your question's not answered, just send us an email, and we'll answer anything we didn't get answered.
Right. Given the variability and some delays in J-1 and the H-1B approvals, what is the time frame of the 90-day count for a physician who's facing a J-1 approval and then a few weeks later a delayed H-1B?
That's a great question. The answer is don't worry about that. It is just a throwaway that's in the law. I think it's rarely enforced. no, we know pretty much know it's never been enforced. So some positions, for example, some states like Texas give out their waivers in September, and the process goes forward, and you might have your waiver process completed by December or January. Say, oh, what do I do? That's put that down way down.
Yeah, we fixed that in the Klobuchar bill, but it's still basically in the law, and we found that it's one of the areas where USCIS is relatively sensible. They haven't given us problems over the years on that issue.
Right.
And then we have one
tornado siren in my. That's every Saturday afternoon. You can tell I'm in Tennessee. That's our weekly ritual.
What's your weekly ritual?
The tornado siren testing.
Oh, I didn't hear.
You didn't hear it? Okay, that's good.
That's what that was. So a final question. What are the options if a physician chooses to return home to satisfy the 2-year home residency requirement of the waiver? How difficult is it to return back to the US and continue practicing after the 2 years are over?
Why is this physician on the call?
They want to come back, but maybe they didn't find a job.
Oh, there are plenty of jobs out there, folks. Go get them. If you didn't find a job and you want to go home, well, you can have non-COVID time or COVID time. Pre-COVID, you could come back after you'd spent 2 years physically present in your country of return.
Right.
Just a point there, don't go to the wrong country. Some people have done that, and particularly EU people live in one country, and you have to go to the country that issued your letter of need. You may come back like anyone else after 2 years. You could come back on an H-1B, a green card, any number of ways. So yeah. One more question, Ben.
By the way, you're not exempt from the H-1B cap if you do that, like you would be.
Yeah, exactly.
So
it really
it's a bit more challenging finding the job you want when you do that.
Yeah. We see very few people going home.
Outreach to congressmen. Who is that most persuasive by? Would that be most persuasive by the hospital CEO or administration, or from the physician themselves?
Both. I mean,
everybody. Flood the congressman's inbox.
Invite everybody to the party you can. You need help. The people you're going to serve need help.
The CEO of a hospital probably knows the congressman personally, and that can sometimes be helpful.
Yes, I have a client who's best friends with Chuck Grassley, who hires J-1 physicians, and you see what we've got from that. But yeah, they're embedded in the community. They're usually, because of hospital, related reasons, have all kinds of occasions to deal with their legislators and the State Department of Health. And we do find amazing success in expediting medical licenses through hospitals.
Mm-hmm.
And they are willing to help, and don't be shy about asking your prospective employer to help. They'll actually—
Every day you're not working costs them money.
Exactly. Okay, with that, please feel free to contact us regarding your immigration issues.
Dan, thanks for inviting me.
Oh, pleasure having you, Greg, as always, and email us your questions, and know that we all appreciate you and honor you. Thank you so much for attending. Have a great day.
Bye-bye.
Thank you. Have a safe weekend. Take care.
Bye.